Good morning. This is docket 9818 CE 100, the application for a CPCN by Ursa Solar to construct the Langdon Mills Solar Electric Generation Facility. My name is Michael Newmark, the Administrative Law Judge for the PSC, and we're here in attendance on Zoom for the pre-hearing conference. That's a hearing that I noticed, and we were able to looks like provide this notice to everyone in attendance. So I appreciate everyone making it here today. We have the applicant, potential interveners, and commission staff in attendance. I did want to note, we did have a service list that was issued along with the notice of hearing, of pre-hearing conference. And I just wanted to get the appearances for everyone in attendance on the record. So we could start out of order on the list here. Let's start with the applicant. Who do we have representing the applicant today?
Eric Callisto from Michael Best and Friedrich.
Okay. And I see Lauren Tan, you're in attendance. You need to turn your microphone on, please.
Sorry about that. Yes, I am, Judge. Thank you.
Okay, great. And Pat Van Buren as well. Please unmute and state your appearance. Unmute your mic, please.
Can you hear me?
Yes, perfect. So just state your appearance. So you're here appearing on your own behalf. Is that correct?
Correct.
Okay. And we have Renew Wisconsin. Who's in attendance for Renew?
Currently, it's just myself, Heather Allen, in attendance for Renew, but I anticipate my colleague, Michael Vickerman, he's doing dueling meetings today, that he'll join as well. Okay,
I think you'll do just fine, so no worries there. And then we also have one other potential intervener, and I hope I'm pronouncing that person's name correctly, but it's Doug Smedema. Smedema. Okay, thanks for correcting me. So I do have a phone line that's connected to the pre-hearing conference, connected to Zoom, but that person's not responding. I don't know if you can hear me, but this is your time to make your appearance. Okay, well, I'm not hearing you at this point. So there will be a few opportunities, I believe, for the potential interveners to comment on, and I'm going to ask some questions. So when it's appropriate, I'll invite this caller to identify themselves again, and hopefully we'll get an answer if that is Mr. Medina. All right, so let's get started. So notice of pre-hearing conference that does indicate kind of the agenda today. Normally, we go through the process in these situations where we identify the parties, the issues in the case, schedule, and any other matters that will facilitate the proceeding. This case is, a little bit unusual from our normal process. We do have a number of requests to intervene that have been objected to by the applicant. So in order to identify parties, we'll need to review those objections, those requests and objections. I did review the requests that were filed and the objections made by the applicant. And just to give people sort of a starting point here, I did want to just concur to some extent with the applicant. I do have a statement here that really deals mostly with the legal analysis. And I think it's just a good starting point, a reference point, so we can all get on the same page as to what the law is in respect to these requests. So let me begin. So in its responses to the 3 contested requests to intervene, the applicant correctly states the law and intervention in a commission CPCN proceeding as provided in Wisconsin Administrative Code PSC 2.21 and the related commission and judicial decisions cited in its responses. In the context of a CPCN proceeding, to intervene by right, a non-participating landowner needs to demonstrate that granting the CPCN will cause an injury in fact, and that the injury is to an interest the law seeks to regulate or protect. To qualify as an injury in fact, the requester need not suffer an injury as an immediate consequence of a decision to grant the CPCN, but the requester must rationally connect approval of the project to the injury alleged. To intervene by permission, the requester needs to show that their participation will promote the proper disposition of the issues and will not impede the timely completion of the proceeding. And finally, all the contested requests to intervene were received after the deadline to request intervention set by the Commission's notice of proceeding. Therefore, these requests qualify as requests to intervene out of time. Before granting such requests, I may consider the following factors: whether the requester had good cause for failing to file the request within the prescribed time, whether any disruption of the proceeding or docket may result from permitting intervention, and if any prejudice to or additional burdens upon the existing parties may result from permitting the intervention. So that's just the law of what we're dealing with here. And I did want to acknowledge the applicant correctly stated the law. I did also want to back up a bit and just present to the interveners sort of a more global consideration, and that is the ability to participate in a proceeding before the Commission doesn't require you become a party. So now you may wish to become a party, you may have a right to become a party, which I will get into that. But there is another option to becoming a party and still be able to present your views to the Commission, and that's making a public comment. That's where the Commission will hold a hearing and will have a comment period available to the public for people who are not parties to the case. They'll be able to submit their comments to the Commission. Commissioners will read them and will review their concerns when reviewing the record in the case. So that's an alternate form of participation, and it doesn't involve the kind of the legalese and the parameters that we set for filing party evidence, testimony and exhibits, appearing at the party session, being subject to cross-examination, basically, being involved in a trial type, court type proceeding. But on the other hand, as a member of the public, that members of the public get the opportunity to express their views to the Commission. Also, what's expected at a party, as a party, is to present not necessarily expert evidence, but to have evidence that is verifiable, that's not merely opinion, that can be subject to scrutiny from different angles, from different perspectives. So that's just something to consider when moving forward, that the opportunity, just because if I rule you're not a party, it doesn't mean you're not able to participate in the proceeding. So I just wanted to put that out there. But just to move on to the analysis that we've laid out, first thing I want to address is whether, because these are intervention requests out of time, I think we need to first understand whether there's good cause and whether I can accept these requests even though they were filed late. Now, I'm not too concerned about this. I think that I do see good cause for the late filings, and that's because, first of all the requesters indicated they had trouble filing the document on our electronic regulatory filing system. And for first-time filers, I can imagine could be problematic. Of course, I mean, the counter argument you could have filed it sooner. There could be a lot of arguments against getting it in on time, but the day, I think one of the requests was a day late. Another request was mailed in was mailed the day of the request, received a few days later. And I know from internal discussions with staff that the mailings were misplaced for a few days. So that did delay those requests being placed on the IRF system. So there's enough explanation there for me to agree that there's good cause. Also, I would probably hold attorneys and sophisticated parties who have appeared before us frequently to a higher standard. I don't think that's unreasonable to say for people who have never been involved in our cases before that I can give you a few days leeway. But also it's something we'll need to address if I do grant party status to the requesters, that they'll need to be able to participate using the electronic system. I see at least two of you are on Zoom, so that's good. You'll need to be on Zoom to participate as a party. So those are considerations we're going to have to make. And then the other factors for intervention out of time is a disruption to the proceeding and any prejudice to existing parties. Arguments can be made that we're already far along the process of reviewing the CPCN application. We certainly get these applications much earlier in advance of when we start the hearing process. But I don't think we haven't set a schedule. We haven't set the issues. So I think there is really enough time here to proceed with interveners without causing disruption and prejudice. So in terms of these requests being out of time, I can grant their review without rejecting them outright because they're filed late. It's a little more complicated when we get to, is there a right to intervene, or if I should be granting permission to intervene. And at this point, I did want to gain some additional facts from the requesters in order to understand a little bit more about the injuries that they're alleged, how the project might affect the interests that they're alleging may be injured, and whether the presentation they wish to make before the commission is something that'll assist the commission in proceeding with the decision. What's the nature of that evidence, and how will it be presented? Through what means will it be presented? So I just wanted to ask one at a time our requesters, the potential requesters, and let me just note that no one objected to the renew request. So I'm going to wait till we get through them all before I grant party status. But I'm not going to be asking questions of renew because there's no objection to their request to intervene. So
Your Honor, this is Eric Callisto. May I just ask a question before you proceed?
Yeah, go ahead.
I do have a couple of things I'd like to be heard on, including the timeliness of the potential interveners' filings. I can certainly wait to the end. I just wanted to make sure that I had the opportunity to respond. I recognize you've already made a conclusion on that, but.
Well, why don't I hear your argument on timeliness before we go forward?
Thank you, Your Honor. And for the record, the applicant is not objecting to the second two prongs of the timeliness statute, meaning we recognize that there's not going to be prejudice to us if this intervention is allowed. And let me take them in turn if that pleases the court. As to Lauren Tan, and as noted in our pleading here, she was certainly aware of this proceeding. She received the EA notice and the notice of proceeding itself, which puts her on notice of the 14 days. And as I think you alluded to, she only started the IRF process apparently on January 4th, leaving only 1 day for it to be done correctly. And I recognize that these are not people who typically spend time on the IRF system. But I question whether good cause is found when somebody jumps onto a system the day before an application is due and finds they have challenges with it. It is clear that IRF was working on those days, both the 4th, the 5th, with multiple filings, including filings in this case.
Okay, Attorney Calista, let me interrupt. Are you going to add anything that's not in your response, in the written response?
I am certainly for Mr. Smeedema.
Okay, why don't you skip to the additional information?
I guess for Mr. Smeedema, he's somebody who's, by his own acknowledgement, not facile with a computer system. He indicated in his intervention request he only has a phone. I think to me that suggests that, whether or not he's going to be able to participate in this proceeding in the long run's in question, but from a timeliness perspective, waiting to the day of and then having challenges, I don't think suggests good cause in this case for somebody with his skill set on the computer system. Finally, as to Ms. Van Buren, as I noted in the pleading, this was postmarked January 13th.
Okay, this is so additional information?
I believe this is additional, or at least an additional analysis, right? Because she could not upload it by her own statement on January 5th, yet she waited 8 days to file or to mail the document in. And I don't know why that 8-day delay would meet on any reasonable standard of good cause. So I don't believe in her case in particular the standards met.
Okay. All right. There. Well, your objections are noted, but I'm going to continue on with my finding that there's good cause and move on to the rest of the analysis. So I did want to start with Lauren Tan. And so I was going to ask this later, but I think because we just had the question raised by counsel, I'm going to actually stop the screen share. I don't think we need that. So let me ask, just as a preliminary question, it does relate to the disruption issue that Attorney Callisto raised, and it's just the idea of if we are able, if these potential interveners are willing and able to participate using the IRF system and comply with the online filing and internet-based participation requirements that we have in these cases. And I think I did share the notice of pre-hearing conference with everyone. So that has sort of the outline of what's generally required for a participating party to file documents and follow the process. So we can start with Ms. Tan, just an indication of your ability to comply with those requirements. How can you give us a comment on that, please?
I have no problem filing online. In fact, as I noted in my reply, I did reach out to the Public Service Commission several times to try to submit my request the day before. However, I did not receive a call back and get any help from the PSC to be able to do that. Since then, I still have not received a call back. However, have managed to get into the system and will be doing so from time to time to make sure that I don't have the same issue, because I was very upset that I couldn't file it the way it needed to be, and then leading to this process. So.
Okay, well, I apologize for that. I do think we had some trouble with our staff. I think the system was working, but sometimes people do have trouble the first time they're making an account and getting on.
I would like to set the record straight that my account was made prior to the day before the filing. I just had problems logging in.
Oh, I see. Okay, well, thanks.
So I did not wait until the last minute to actually make an account. I had one created, but had problems logging in, which have since been rectified.
Okay, thanks. So Pat Van Buren, can you comment?
So I did have problems getting mine to go through, and I did do my documents earlier than the deadline. I had signed up to receive any emails that were associated with docket 9818 CE 100. I had received one document notice, and then from then on, I didn't receive anything else from the PSC. I went on the calendar docket. There was no documentation either on December 22 or was none on the deadline date that it had to be in. But I realized that I could not go through on the 4th. And then with a weekend being in there, I made sure that I mailed it in, and then I reached out to the PSC because I didn't hear from them, and I didn't get a phone call. Friday I reached out. On the 21st, they didn't call me back, and then on the 23rd, Jackie Gardner from the PSC called me back and apologized that they had misplaced my document, and they had found it in another building in an incorrect mail slot.
And I guess my question is, going forward, are you able to file, if you were to file testimony and exhibits, file them in writing according to the format we require and using the IRF system and the email service list? Is that something you're able to comply?
I believe I could do that.
I'm sorry, repeat that.
I believe I could do that.
Okay, great, thanks. So I did want to ask the same question of Smedema. Smedema, to say that a few million times. Doug Smedema, I do notice we still have that one phone caller that's not hasn't indicated their identity and has not unmuted their phone, but it is an opportunity for you to comment on your compliance with the filing requirements if that happens to be you on the line. Okay, we're not getting a response. Okay, so so I'm glad we cleared that up. But so my ruling stands on good cause, yes, and the other elements of out of filing intervention out of time are not raised. So we'll move on. So looking at intervention by right, I did want to get some information from the potential interveners, and I know we just had Michael Vickerman from Renew just join us, and I just wanted to mention that I'm not going to be asking questions of Renew because their intervention request has not been challenged. So thanks for appearing, but you're just waiting for scheduling and issues. So sorry about that. But so just looking at intervention by right, I did want some information from the interveners. And let me just start by saying, looking over the requests, there's the tenor of the requests focus on the standards for granting a CPCN that the commission must analyze with respect to public interest factors and environmental impacts. Those are the things that, to me, seem to be what's concerning the interveners. We have particular statutes that deal with that, standards that the commission applies to CPCNs in dealing with those elements of the case. So let me read those provisions for everyone's edification here. So this is Wisconsin Statute 196.491 sub 3 sub D, paragraph 3, which states the design and location or route is in the public interest, considering alternative sources of supply, alternative locations or routes, individual hardships, engineering, economic, safety, reliability, and environmental factors, except that the commission may not consider alternative sources of supply or engineering or economic factors if the application is a wholesale merchant plant. And that's the kind of application we're in right now, a wholesale merchant plant. So the other provision the commission applies to this case would be the proposed facility will not have undue adverse impact on other environmental values, such as, but not limited to, ecological balance, public health and welfare, historic sites, geological formations, the aesthetics of land and water, and recreational use. And that section is 196.491 3D4. So I was curious about if the requesters could explain, given the standard of request intervention by right, so you need the injury to an injury in fact protected by the law. My question for the interveners is, what is the proximity of the project to your alleged injuries? I'm sorry, what's the proximity of the project to your alleged injured interest? So when answering that question, I'd like you to note that when filing for a solar project, the commission requires applicants to provide the names of all the property owners within a 1 mile buffer of the project. So that's something that the commission requires to know that who owns property, owners and residents within the project boundary. We want a list of owners within the project boundary. We also want a list of property owners and residents out to a distance of 1 mile from the project boundary. So that indicates to me that that is where interests, property interests and interests in terms of individual impacts to the project, they lie within that field, at least as a prima facie case. So there may be other impacts people could allege, or there may be impacts that don't fit the standards. But for me, that's a benchmark to say, if you're in this area, we already requested your identity to be known. We've mailed out the notice of proceeding to you. So we invited these requests. So whether they meet the standard or not by intervention by right depends on some other factors. So just to review, so the question would be, what is the proximity of the project to your alleged injured interest? So we could start with Lauren Tom, please.
Well, as Mr. Callisto noted in his response to my request, I haven't measured, but apparently I'm 815 feet away from a solar panel. They will impact my community and the school district here. And this is a community that I've lived in most of my entire life. So I guess my ultimate goal is to ask questions that don't seem to be answered in the public forum, and try to make sure that this is something that will not harm our community and specifically the area in which I live.
Okay. So anything particular to your property that you're concerned about?
Property values, for one. We purchased this particular piece of property and built a home here as part of a retirement plan. And I'm concerned about specifically the impacts that will do to property values. I'm also concerned about what this will do to ratepayers of energy in general, the purchasing and building of projects like this.
Okay, all right. Okay, so let's move on to Patricia Van Buren.
Yes, thank you. I am within 25 feet from my property line to a solar panel array. I will have 40 acres to the south, 40 acres to the north, 8 acres behind me with a possible another 40 acres behind that. And then across the road, I will also have 20 acres. I was incorrectly yesterday they called me from the PSC. Adam Inwell spoke to me. He did not understand that I am in phase 2. I have a map from Samsung showing that I am in fact in phase 2, and that I will be completely surrounded on all 4 sides. My whole road, even the conservation club, past the conservation club to the south, will also have solar panels across the road. I will have no view from my house that will not have solar panels whatsoever.
All right.
I also feel, I'm sorry, go ahead.
No, go ahead, that's fine.
I also am very concerned about the fire risk because I am so close. It poses a great risk out here because I've seen a fire in the wildlife habitat from the Paradise Marsh across the road that burnt 1,200 acres. And if it had crossed the road, it would have burned my home. And it was very quick, it was very fast, and the fire department could not extinguish it. So they just had to let it burn out. So that's a big concern for me, especially since we don't have any fire trucks that emit foam to put out a fire. And being completely surrounded, I don't think I would have a chance to survive a fire if that did start, because the installations are locked. And I've asked and requested how are they going to get unlocked? How is the fire department going to get in? And we don't have a fire truck that emits foam, and we don't have firefighters that are younger than about 50 years of age. They're all older, and they aren't trained. So I have health and safety concerns as an RN. I have those health and safety concerns to my family, being in the fire risk. Also to the wildlife impact. I see deer on the south side of my house every night. I can see as many as 20 of them. And that will be in the field where the installation will occur. So the wildlife will be greatly impacted. The jobs that I fear will be lost. The canning factory had beans in the property next to me. They have corn in the other property around me. And I feel that we will have canning factories in Cambria who will not have those jobs any longer.
Okay.
With processing of the beans and the processing of the crops.
Okay.
Your Honor, may I respond to at some point to both of these?
Just a minute here. Let me ask Doug Sedema, any interest, any answer to this question? What is the proximity of the project to your alleged injured interest? Okay. If he's connected, we're not getting an answer. Okay. Yeah, let's get a response from the applicant. Go ahead, Attorney Callisto.
Your Honor, and I'll take them in reverse order, starting with Ms. Van Buren. As I noted in Exhibit A to our opposition to her intervention, her property is approximately, 1.94 miles to the east of this project. She references Phase 2. Phase 2 is a potential CPCN project by the same developer. It's not the project that's in front of the court right now. So all of her arguments are quite diminished because she is not proximate to this project itself. And as to the specific arguments about things like fire risk, wildlife, lost jobs, again, they just aren't relevant to somebody who's not proximate to the project itself. As to Ms. Tan, the bulk of her response is about things like impact to her community or the impact to ratepayers on energy costs. Again, both of those are not the kind of harm that would generate a substantial interest by an individual in this case. I'm not questioning, at least as to community, the ability of somebody on behalf of the community to argue that, but that is not Ms. Tan. Ratepayers, as the court knows, this is not a ratepayer funded project. It's funded by a merchant, so there is no impact to ratepayers from this project. I'll stop there.
Right. Okay.
If I could, Judge.
Yeah, go ahead.
Part of the reason why I chose to become an intervener is specifically from a discussion that Mr. Callisto had at the town of Springvale. I can't remember the exact date, but he had told us himself that we would be able to be an intervener. So I was quite surprised to even be here today when part of his discussion with the community was that we would have a chance to intervene if we wanted to. So I'm questioning why suddenly it seems to be so detrimental that I become a part of this hearing.
Is that true, Mr. Callisto? Maybe you could clarify that.
I do have a recording of that meeting as well, which I could provide.
Okay, that won't be necessary, but thanks.
Yeah, Your Honor, I'm happy to respond, right? I don't recall the specific question. I certainly was at that meeting and answered a lot of questions. I would imagine my response to a request about intervention was that people are going to be allowed to intervene, whether I said it or not, that presumes that they meet the legal standards, right? So that is the answer.
That was a very misleading statement then at that meeting.
Okay, well, thanks for clarifying that. Let's move on. Yes, so in terms of, I don't have many other facts for Mr. Smedma, but I can comment on his right to intervene. So looking at the Smedma request, The request characterizes this Medma property as being 20 acres of country land. So I was going to ask him to clarify whether that was a non-residence, whether it was agricultural. I'm going to assume it is. It's located outside the property boundary by 0.65 miles, but within the 1 mile buffer. When it comes to a utility scale solar project, Commission has determined it has less overall environmental impact than, for instance, a fossil fuel combustion plant, because it receives a lower level of environmental review than other projects, like, for example, a coal plant would receive. Nothing appears to make this particular project different from other solar projects that I've been in experience with, and we've done at least 10 so far in the past 2 to 3 years. So I'm not seeing that there's a reason that the proximity of the Medma property is going to impact an alleged interest of the requester. So given the type of the proposed project and the property's lacking proximity to the project and the property type that I gleaned from the request, I don't believe that there's that those factors give rise to an interest legally protected by the Commission's duties under the CPCN statute.
Judge Newark, could I interrupt? Could I ask Mr. Callisto, is phase 2 not going to happen? That I could not, would I have another chance to be an intervener in phase 2? And what is the result of you saying I am in phase 2, which will compromise all around my 5 acres, surround me completely? What are the results of phase 2 at this time?
Okay, well, let me address that. My opinion is that we're not in phase 2. We're in phase, if there is a phase 2, then this would be a phase 1. Doesn't really characterize this phase 1, but we're in the project we're in right now. Intervention in this project would not be the same as intervention in any phase 2 project. It's separate projects, separate standards, and I think what you're getting at is it's a different proximity to the project. So so I did want to just indicate that from the request, the Van Buren Properties 5-acre homestead, but as indicated in the response from the applicant, it's outside the project boundary by 1.94 miles, and outside the 1 mile buffer by, I assume, 0.94 miles. So being that far away, I don't believe, again, that this property is, it lacks the proximity to the project that would give rise to a legally protected interest that the Commission needs to recognize. So having said that, this has no preclusive effect on if there's a phase 2 that gets applied for, and that phase 2 is designed to be surrounding your property. I think you would have another chance to be a separate project, separate application. You'd have a separate chance to intervene and be involved in that case as an intervener by right. When it comes to the TON request, it's uncontested that the TON property is surrounded by the project, and I didn't have a picture of that in particular, but that is the situation, right? There's how many sides of your property are involved?
2 specifically, but Mr. Callisto added the third that I didn't reference myself before. So I will see them from the east, the south, and the west on the western point of my property.
Okay. So I know the stated, Laurenton's stated interests were very broad in the sense of community impacts and impacts to, I think, some economic impacts, the school district. I'm not sure exactly how that would be fleshed out at the hearing, but I think being that close to the project, there certainly will be impacts. So for example, aesthetic value, aesthetics of land and water, recreational use, ecological balance. These things are, because of the proximity, things like safety, environmental factors, individual hardships. These are things that, being so close to the project, I think are recognized, at least for in the standards that the commission should consider the views of Ms. Tan. Having said that, I just wanted to make sure we are going to deny by right the intervention of Doug Smedma and Patricia Van Buren. I just wanted to hold off on the intervention by right on for Lauren Tan and look to the permissive intervention standard, because I would like to know, in terms of the requester's interest in the case, what evidence do you plan to bring to bear to the questions of public interest factors and environmental impacts previously mentioned? What expertise do you have or will engage to present this evidence? So let's hear from Ms. Tan first on that.
So I am currently working with some professors and other experts in their field to be able to present studies that question like environmental impact and those sorts of things for the project. I apologize if I needed to have that available today. I didn't think I would need any of that until briefings started. So I am working on gathering scientific papers, studies, and working, like I said, with individuals to be able to make sure that I'm asking the right questions.
Okay, so you'll be consulting with experts? Is that one way to phrase this? Or
yeah,
will you be bringing them into the case to testify?
Possibly.
Okay, yes. So in the notice of pre-hearing conference, I did just mention that one of the items to address was the potential intervener's plans to introduce expert technical evidence and personal non-technical opinion, or both. But it seems on its face that you do have a plan to present expert testimony. How about Patricia Van Buren, if you were allowed as a permissive intervener, what evidence do you plan to bring to bear to the question of the public interest factors and environmental impacts we mentioned? And what expertise do you have or will engage to present this evidence?
So I've been reaching out to people who currently have arrays of solar panels on their property and who have experienced for a number of years now what's been happening in their area. And I've also reached out to the DNR and keeping up with the impact studies of wildlife on different situations that are involved.
Okay. So can Doug Sedema answer that question? The person's on the line. Okay, I'm not getting a response. All right, so any comment from the applicant on the nature of the testimony that interveners plan to bring to the case?
No, Your Honor, and based on Ms. Tan's representation that she intends to, at this juncture, at least potentially bring in expert testimony, I'll withdraw our objection to her intervention. And I think you've already ruled on her intervention as of right.
Okay. All right.
As to Ms. Van Buren, I don't think she's made a case on permissive intervention, right? Reaching out to people who have solar farms is not the same as potentially proffering testimony. And of course, her reference to DNR is nothing additional to this case. As the court well knows, we're going to have substantial DNR testimony in this case already. So to me, what Ms. Van Buren seems to continue to have an interest in is something that's more akin to a public comment. And I would suggest she's not met the standard for permissive intervention. She won't bring additional value to this case. It's not already going to be there.
Okay. Any response, Ms. Van Buren?
Yeah, my response is about phase 2 again. I did not receive an answer as far as when they believe phase 2 will go through, if it does go through, or if they have any idea if it will. Being that the proximity to my house is so close to phase 2, and I did not receive adequate information even about really phase 1 via email after my request. I would like to know, how does phase 2 actually get implemented? Is it implemented right after phase 1? Or is there a time period again where we go back to going to reply and submitting for intervenor status again? And when is that status going to be called for?
Okay. Well, I can answer part of that, which is that when an applicant, phase 2, if there is a phase 2, would require a separate CPCN application that would get filed with the commission. The commission would have to deem that application complete, and then we would go through the process of notifying the landowners within the proximity of the project. Again, within the, I guess would be the 1 mile radius of the project boundary, would get the same notice that was sent out in this case. And if it's true that you would be surrounded by solar panels,
yeah, go ahead.
you would be on the list to get a notice. I would expect that you'd receive some other contacts from the applicant prior to that, but before you get the note, before the notice of proceeding goes out, there's no real process for accepting a request to intervene. So that's what triggers the process for intervention, is getting that notice of proceeding, which, if the process worked, you would receive that.
So I would receive a letter regarding that I'm within the 1 mile radius.
Yeah, you'd be
as a non-participant.
Right now, if there's a phase 2 and when the application would be filed, I have no idea. I have no way to know that. If Attorney Callisto has any information he can give us today, feel free, but I don't know if that information is available.
Yeah, Your Honor, there is no,
hang on.
Right, there's no information on that, Your Honor. There's been discussion of a phase 2, but as the record currently reflects, there is no CPCN application. There's not even been an engineering plan filed on any potential phase 2. So that is a thought, but it's nothing more than a thought and a possibility at this time.
Okay.
Hello, can anybody hear me now?
Yes, we hear you. Can you identify yourself, please?
Yeah, this is Doug Smeedema. I've been hearing the whole thing, but Lauren suggested that I redial this again, so now I can hear you. Thank you.
Okay, great. Well, thank you. So I'm glad you could connect. Okay, so at this point, I did want to complete my ruling with relation to Pat Van Buren, and I'm going to accept the request in opposition to her intervention. I think that the proximity to the project is such that she has no right to intervene. The nature of the project, like I said, the nature of proximity type of project indicates that a right to intervene does not exist. And I believe that the evidence that she would propose to bring to bear is something that will be covered through environmental review, the environmental assessment, and an analysis of the application by commission staff and staff of Wisconsin DNR. And also, we will wait to see if there's a phase 2, and then Ms. Van Buren is certainly welcome to refile that or file a new request to intervene in that docket. So it'll be a separate docket, different number. So you just look for the notice of proceeding that will begin that process. And I would assume that you'll also be hearing from the applicant well in advance of that time, if you're that close to the proposed project boundary.
When does the letter go out?
I'm sorry, one at a time. Let's go ahead, Ms. Tan.
I'm just wondering, maybe to get a little bit better understanding of that. Renew Wisconsin does not live close to the project. There's not even an office anywhere near the project. I know we're not contesting them today, but just for my understanding, how how do they have the right to intervene when they aren't even a part of the community?
Right. Okay. I can address my reasoning for that. So usually I do issue a separate order that grants intervention requests, and normally requests are not contested. And with the request, what the order normally says is, I'm granting the following uncontested requests to intervene, and I just list them out. So Renew has been involved in many cases before the commission, and usually that's the kind of determination I've made. I accept their uncontested, undisputed request, and we move on, and they are a party in the case. Their request to intervene does explain sort of the basis of why we grant their request, and also probably why no one has really acted in opposition to their request. They've been in existence since the early 1990s, and they've been promoting renewable energy both in the legislature and through commission proceedings. So I take that experience as a degree of expertise in both how we process cases, having a historical knowledge of cases and statutes that come to bear in CPCN proceedings and other cases before the commission. And also they do bring expertise, expert witnesses. They do provide information that does provide the commission with the ability to promote the decision-making process. Essentially, I don't usually rule whether I don't know if I've ever ruled whether they have a right to intervene or whether I'm accepting them as permissive intervention. And that's what I was saying in the beginning, that no one really has pressed me to make that decision before or ever. So when I grant their uncontested request, I just make them an intervener without making that determination. So, but at least I know that they do, in most cases, bring evidence that's useful for the commission in its decision-making process. So I'm expecting them to do so in this case, and they've been involved in many cases involving utility-scale solar projects. They've been admitted as a party and have presented expert testimony. So I would expect them to do so in this case as well. And because no one is opposing them, like in my normal process, I will grant the intervention request without much analysis. So that's kind of the basic understanding of why Renew would be a party in this case. Even though it's not a member of the community, it does. That's not the only standard for becoming a party. It's whether your participation can provide benefit to the record in the case, can assist the commission in making its decision. So, so let me address, I think, Ms. Van Buren, did you have a comment you were going to make?
No, my comment is, well, I guess I do have a comment. So I'm going back then to the phase 2. In some cases, I've heard they put phase 1 through and then they automatically just go with phase 2. And you're telling me that's completely separate documents. So it doesn't go that direction. And it would be probably a lot longer in between than months or years, or the time frame. I'm just concerned about the time frame.
I see. Yeah, I can't speak to the time frame. I don't think anyone knows the time frame, but like I said, you will get a notice. The notice I know you will get, if the mailing list is correct, you will get the notice of proceeding that tells you that you can intervene in the case. And what I would suggest you do is get in touch with the applicant, ask them to contact you when they file a request. When they file the application, you can monitor the commission's website and subscribe to the docket that would be potentially be that phase 2 case. Yeah, definitely monitor the commission's website, stay attuned to public meetings involving the applicant. I know they need to attend meetings in the community before they apply for the
Phase 2.
file their applications for phase 2, right? So there should be adequate, you should be able to get knowledge of that, whether phase 2 is being proposed. And like I said, the application will be filed on our website. So check in there. And also you'll get the notice of proceeding, which will indicate that time frame to file for intervention.
So why do you think this is rare that we've been, the applicant has opposed our interventions
I don't
in
know.
this case?
I can't speak to that, but
Because you've said that several times.
Yes, that's correct. We don't usually see many opposition that get filed, but it is part of our process. It is a legal proceeding, and that is a right of a party to, they do have the opportunity to oppose request intervention, and that makes me do this. So that's why we're here.
We were talking about proximity, and then, you know, being 1.94 miles or proximity being 25 feet off my property line. So I do feel that proximity should have more bearing if you're completely surrounded, like Lauren, of course. And I would be potentially.
Yes, but we're not speaking about phase 2 now. So let's put that to bed. You'll just have to wait until you get that phase 2 becomes a reality. And once it does, I'll be able to hear your request to intervene.
Okay.
Yeah, but at this point, let's move on. I did want to introduce Doug. I'm sorry, I'm going to mispronounce your name again. I've done it a million times, and now I have you to correct me. So could you please pronounce your last name for me?
Yes. Thank you for giving me the opportunity to speak. This is Doug Smeedema.
Okay, thank you. So you heard the conversations before you were able to speak, is that correct?
Yes, I heard everything except when Lauren texted me and said, try hang up and redialing, and then it worked. So
okay, all right, great. So we did go through the standards for intervention, and I would like to get you just to make sure I understand your request. Characterize your property as 20 acres of country land. And I made the assumption that's a non-residential property, or it may be agricultural land. Is that correct?
That's correct, but it has a 3-acre beautiful building site that I planted lots of trees on, and there's a wonderful shed out there right now that all my grandsons, we go deer hunting and so forth, and that's why I'm objecting, because I do believe your phase 1 here is going to have 20 miles of 8-foot-high fencing stopping the wildlife in the area. And my main intervention comes from a University of Rhode Island article that was funded by the United States Department of Agriculture, and it states that all properties within 1 mile of a rural solar farm will lose anywhere from 5 to 7% of their value, and I'm sure that that should be introduced to the Public Service Commission. It was completed in September 30 of the year 2020, and again, that was a grant from the United States Department of Agriculture. There is plenty of harm being done out there, not only to my property, which is 0.65 miles from the closest array at this time, but there's almost 50 individual homes out there that are going to be affected by this solar farm. So that is my main contention, and I thank you for letting me speak.
Okay, great. Well, thanks. So another question I had was, when it comes to participating in the commission's process, would you be able to file online, create documents electronically and have them filed with the commission and emailed to the service list? You'd also need to be on Zoom with a camera on in order to participate like we require parties to do. So is that something you're capable of?
I imagine with a lot of help, I'd probably need help from my son. My wife is disabled and she used to do it, but she's no longer able to.
Okay, but it's a possibility. Okay.
Yes.
And another question I had for the potential interveners was, what type of evidence do you plan to bring to bear on the issues that you raised? And what expertise do you have or will engage to present the evidence?
The evidence I've got printed out right now, and well, I have no expertise in pricing of things, but I am a retired master electrician, and I've worked on inverters before, and the 70-some inverters on this process are going to be humming consistently whenever there's daylight. So that's the only expertise I have as a master electrician.
Okay. So let me ask the applicant if they have any comment on what we learned from potential intervener Smedema.
Your Honor. Yeah, Mr. Smedema, I think, is talking about, if I understood him correctly, filing effectively a literature relating to property values. And I would suggest that is something that's more appropriate for a public comment. I didn't hear anything about testimony, either experts on his behalf or his own. I will take him on face value that his son or somebody else will help him comply with all the IRF requirements here. But as I said in the file, and I believe Mr. Smedema's comments are more appropriately characterized as something that would be a public comment and not of the necessary weight and value that's appropriate for intervener.
Okay. Yeah, so I'm a little bit torn, I must say, because it's come to my attention in the recent past of interest in the aesthetics of land, water, and recreational use is something the commission needs to find. There's the project will not have undue adverse impact. And I suppose the issue of hunting on land on property that's surrounded by a solar field may have an impact on recreational use in terms of hunting. So I don't know if I'm really prepared to rule unless I know a little bit more about this. But that is one of the allegations the potential intervener is making, that they hunt in that land. And that was correct, right? I heard that correctly, Mr.
Yes, that is correct.
Your Honor, may I ask one more question, or
Yeah,
just, if you
sure.
can ask Mr. Smedema, if I can't, does he have email that we can use, for example, for service? And if the ALJ is inclined to rule and make him an intervener? I
do. He's on the service list.
Okay, I stand corrected then.
Yes. So he would be on the service list. So, so in terms of land, the aesthetic value and recreational use, I think there's probably enough, given his proximity is, so you're not surrounded by the project. That's correct. So the proposed fencing doesn't abut your property, does it, Mr. Smedema?
That is correct. But just like Pat, after we received this letter, my son did, phase 2 from Langdon Mills says in mid-2023, okay, they will submit for application for their phase 2, which will be getting that much closer to my property, actually on 3 different sides, even though it will be 2,000 to 3,000 feet away. Okay. And this is where Pat and I come in big time. If phase 1 doesn't happen, then phase 2 will not happen. But by this letter sent out by Langdon Mills, June 14th, the phase 2 will be submitted in the middle of 2023, And then we will have double the problems we have out there that we have now already with property value losses. And I know many other hunters in the area are extremely upset over this.
Okay. I see. All right. So I think I have my answer here. So I'm going to make you wait until phase 2 is filed along with Ms. Van Buren. And I think the struggle I'm having is I do recognize in the statute that recreational use is indicated as something the commission needs to consider. But I think in terms of proximity of the current project, I don't see that it raises to the level of legally protected interest by that statute. So now in terms of I know you mentioned phase 1 will come and therefore phase 2 will come. I don't think we can be that definitive. I think that in terms of the legal standards, the injury that you're alleging that would be caused by a commission decision to approve phase 1 that does not guarantee the approval of phase 2. It's a separate proceeding. It hasn't been applied for yet. So there's enough of a disconnect between any approval the commission will give in this proceeding to the outcome of any phase 2 that may or may not be actually, proposed in an application. So because there's that disconnect, I don't think we can connect the two, saying that, this case will determine your impact to an injury you're alleging on your property. But hold that in reserve for if there is a phase 2. I would be curious to investigate the recreational use aspect of this. If your property is in close proximity to those fence lines, that may be the case that we'll need to hear from you on that issue. So,
Judge, can I ask what proximity is close enough? I mean, he's within the mile radius of the project. I'm just trying to get a better understanding because, my 800 feet was contested. Doug's about just over a half a mile. I'm just wondering what is the proximity that is generally looked for?
Yeah, I don't have a number for you, but I get the sense that his concern is the phase 2, which will be much closer to his property. So I think that's where the impacts are going to affect him. And actually, that's all potential, of course, but in terms of the, undue adverse impact to recreational use, if that's one of the claims that he'll make in the phase 2, we'd have to flesh that out to see. I mean, I would like to see, it might be something we want to see evidence on is, well, how does that impact recreational use, having a fence line in that close of a proximity. But I think if you're looking at, over half a mile, I think that's just not what I would consider close enough. So, so let's move on. So we have Lauren Tan. I can name you as a party. Doug Smedma and Patricia Van Buren. I'm going to deny your request for intervention, but stay tuned for phase 2. The uncontested request for renewal I'll grant as well. So we do want to move on and speak about the issues and the schedule. And that's in the notice of pre-hearing conference. I can display that on the screen. So now we just need to hear from the people I've admitted as parties. The applicant, of course, is a party. So the rest of you can stay on the line. That's fine, and observe as a member of the public. But you're also excused if you want to be. So on the screen, I do have the proposed issues. This is our standard issue. Does the proposed project comply with the applicable standards under Wisconsin statute sections 1.11, 1.12, 196.025, and 196.491, and Wisconsin Administrative Code chapters PSC 4 and 111. So what we usually do is that's kind of the broadest standard we can make. It just cites all the statutes that we bring to bear in these cases and allows parties to address those issues, those standards as they see fit. I don't see that we need to get into specific subsections of that or flesh out specific issues of controversy in that broad bucket. So if parties are agreeable to those, to that as being the issue, I'll approve that.
No objection from the applicant.
Okay.
No objection from Renew.
I have no objection, Your Honor.
Okay, thanks. And then the schedule in terms of filing dates, we have listed here. So I just put together proponents of the project, and then opponents and commission staff, rebuttal, surrebuttal, the hearings, all listed here. Getting a little bit of any comments on the schedule we have on display?
Your Honor, let me start. I suspect we're going to hear something from Renew as well. I conceptually have no problem with the dates that are laid out, and my witnesses will be available for the hearing. The technical hearing is scheduled. I do have concerns about the first date of direct testimony and how the court has framed it as project proponents. I don't know that I've seen that before. I may not remember all the cases I've been on, but I would suggest that we adopt the traditional model with the applicant going first and then interveners and commission staff going second. I do think at some level it presumes a party's position, and while Renew in this case, who's the obvious proponent along with the applicant, tends to support these projects, they do on occasion ask for conditions that we may or may not agree with. So I'm not sure it's fair to necessarily lump them in fully with the applicants. I do think also there's an issue of a timing differential, which just requires, I have no objection to the due date for our testimony, but it requires a shorter period of time for Renew to get their testimony together than they would otherwise have if they were put with the traditional staff and other intervener response time. So I would prefer we go back to the traditional model on that.
Okay.
That's all from us.
Okay, so my experience in the solar cases that Renew, there may have been conditions that I suppose weren't expected from the applicant, or maybe not completely agreed to by the applicant. I guess what I meant by project proponents is persons generally in agreement with the application rather than a proponent of every aspect of the application. So I apologize for any confusion there. Any comment from Renew?
Yes, Your Honor, thank you. I do not have an issue with the dates proposed, but I do not understand why we are dividing interveners into two camps. And I think there's a basic issue of fairness there, in that the due date that is proposed for us is 5 weeks before the due date for opponents. We can certainly meet the standard of presenting testimony by March 24th. That's not an issue for us, and the rest of the dates in the schedule look fine. But we would have extreme difficulty being able to generate direct testimony by February 17th, because I will be out of the country until February 16th. And then I have some medical procedures to undergo later on that month. So I would request that we be treated the same as the other intervener and be subject to the same set of deadlines. Thank you.
So, and I'll respect that your personal issues there, but I was just curious, do you anticipate?
Can I, Your Honor?
I'll get to you, don't worry.
Okay, thank
I
you.
just wanted to follow up with Mr. Vickerman. I just wanted to be curious. I was curious if I will anticipate something filed in this case other than what I've seen in the past few cases.
Well, it'll be similar certainly to filings in the previous solar dockets, especially this current wave. I anticipate there will be at least one question and response specific to Columbia County. And that involves a little little ad hoc research. And so it's not something that I can easily replicate, though admittedly much of what I produce is based on previous submissions.
Okay. Yeah, go ahead, Ms. Tom.
I just wanted to mention that the applicant has made it clear from his filings today that there are proponents and opponents to this application. And I have no objections to anything that you have listed there, and do believe, since Renew Wisconsin has been a party to these proceedings several times previously, that they should be still considered project proponents, since they seem to not copy and paste testimony, but have the same issues that they bring to each hearing. Okay,
understood. Well, I don't want to make too much of this. I think, yes, my anticipation was we'd be seeing basically the same Renew testimony as we've seen in the past, and which is generally in favor of the projects. But on the other hand, it'll be no surprise as to what we get. So having them file with other intervener testimony is probably just as fair as having them file early in terms of giving people enough time to respond. So I can revert to our normal process. We'll have direct testimony of the applicants listed, and then direct testimony of interveners and commission staff. And yeah, I will look forward to seeing the additional analysis from Renew in that testimony. But in terms of the other dates or the dates themselves, are we okay with the timing of the filings and the hearings? I think we heard from the applicant, but from other parties.
The only date that I question is March 24th, only because I am possibly scheduled for a medical procedure then. I don't have the exact date yet. I'm 7.5 months pregnant, so I will not get that date anytime soon, but I am not anticipating, as I mentioned earlier, that it would be an issue, and I'm hoping to have that filed previously. I would just like to make yourself aware that I may not be able to respond as quickly around that time. Okay, I see. Well, we'll try to respect that, and if you can give us advance warning of any deadlines you may miss because of medical condition, then let me know. Just email the service list. I should know next week a date. I'm hoping after discussion with my doctor next Wednesday, and should be able to present that as soon as I can. So thank you. Okay, great. So at this point, I'll order the schedule as we've listed it on the notice pre-hearing conference, and then we'll make adjustments as necessary. Hopefully, we can get agreement from parties and staff. So just as part of our process, any agreements of this sort that are filed with representation that everyone agrees, including staff, goes into effect immediately I don't have to rule on those requests. So if it's simply changing a date that everyone agrees on, except for the hearing dates, then that's the easiest way to get those changes made. Okay, and I just want to make sure commission staff, just had a quick question for you. I don't usually get to ask this because we don't do pre-hearing conferences very often, but we are expecting testimony from DNR. Is that correct?
So is it, can you comment, Cara?
I haven't, I mean, we generally do have DNR testimony.
Okay.
I haven't specifically asked them, but we generally do.
Okay, I thought we shared the schedule with them first. Okay.
Potentially.
Okay, all right. So I guess at this point, I think we can just go off the record, give the court reporter fingers a break here. I did list all the what we call the facilitating matters that are displayed in the documents attached to the notice of pre-hearing conference. So especially for new interveners, if you had a chance to review that, do you have any specific questions or maybe something that looked confusing?
Not at this time. I'm still working on trying to get through it and comprehending what is all entirely expected of me. But I will be sure to reach out if I have any questions ahead of time.
Yeah, okay, and you can use, so Cara Kuntz is on the line here. If she's the primary contact, if you have questions about the facilitating order, and if she can't answer, she can ask me. But it's best to go through her as a primary source. So
thank you.
That's helpful. So I just don't know if there's anything that may jump out at me that people usually ask. Nothing's really coming to mind. So hopefully it gives you enough background as to what we're expecting. And yeah, don't hesitate to ask questions about filings. Also, you can look back on the other dockets. It sounds like you've already done that to see how things are formatted and presented in writing.
Judge, could I was kind of checking emails, and you're correct. We did share the schedule with DNR staff.
Okay.
Yep.
Okay.
Just wanted to confirm that.
Yep. Okay. Thanks. All right. So I think we have everything we need for the pre-hearing conference. Parties issue schedule, other matters. So at this point, I want to wish everyone a good day and thanks for joining us. Appreciate everyone's participation and being involved in the process. Look forward to seeing some of you sooner than later, but thanks very much for attending, and we're adjourned.